student groups to use its facilities when classes are not in session, then denying access to a religious organization solely because of its religious viewpoint would likely violate the Free Speech Clause, viewpoint discrimination, and would not be required by the Establishment Clause. Providing equal access on neutral terms is generally permissible.
And religious displays on public property, like a nativity scene or menorah in a public park during the holidays. How does that work?
This is very context dependent. A display of the Ten Commandments on public property is generally not allowed if its content suggests a predominantly religious purpose, like inside a courthouse. But government holiday displays that include religious symbols, like a nativity scene or menorah, alongside secular symbols, like Santa Claus or reindeer, are generally permissible, especially if sponsored by the government as acknowledging the holiday season in a diverse way, rather than endorsing a specific religion. The overall context and message matter. As for legislative prayer, opening legislative sessions with a prayer is generally permissible due to its long history and tradition, so long as it doesn't proselytize or coerce participation by non-believers.
So that's the Establishment Clause, preventing government from establishing or endorsing religion. Now for the other side of the coin, the Free Exercise Clause, which protects individual religious freedom to believe and practice.
Right. The Free Exercise Clause protects two distinct aspects: the freedom to believe and the freedom to act or practice. The freedom to believe in any religion or none at all is absolutely protected and cannot be restricted or penalized by law. Therefore, the government may not deny benefits or impose burdens based solely on religious belief, require affirmation of a belief someone doesn't hold, or determine the reasonableness or truth of a religious belief, though it can inquire into the sincerity of the person asserting that belief to prevent fraud.
So belief is absolute. What about religious conduct or practice? Is that also absolutely protected, or can the government regulate it if it conflicts with general laws?
No, religious conduct receives significantly less protection than belief, especially under current Supreme Court doctrine. State laws that intentionally target religious conduct, meaning they are specifically designed to suppress or burden a particular religious practice because it is religious, are subject to strict scrutiny. If a law aims to suppress a religion, the government must show a compelling interest and use the least restrictive means.
But what about laws that aren't targeted at religion, but just happen to burden someone's religious practice, like a general drug law affecting sacramental peyote use?
That's the key issue under modern free exercise doctrine, stemming from the Employment Division v. Smith case. Neutral laws of general applicability laws that apply to everyone equally and don't target religion, but happen to have an incidental impact on religious conduct, like that drug law affecting peyote use, are generally subject only to the rational basis test. This means such laws are usually upheld, and the Free Exercise Clause generally does not require religious exemptions from neutral, generally applicable laws, unless the law substantially burdens religious exercise and triggers statutory protections like the Religious Freedom Restoration Act, RFRA, at the federal level, or similar state laws. So, under the Constitution alone, conduct can be regulated by neutral laws, even if it burdens religion. Freedom of expression and association, Chapter 8.
Chapter 18 is a vast and critically important area, especially for the bar exam. Freedom of expression and association under the First Amendment. How does the First Amendment protect what we say, what we do symbolically to express ourselves, and with whom we choose to gather or associate? It's really a core element of individual liberty in a democratic society.
This is truly a cornerstone of individual liberty and democratic functioning, and yes, it's frequently tested. The First Amendment protects a wide range of expressive activities. Let's start with some general principles about regulating speech. First, expressive conduct, also known as symbolic speech like burning a flag in protest, wearing an armband, or participating in a silent march, receives First Amendment protection, but it's often subject to a slightly lesser degree of protection than pure speech. A regulation of expressive conduct will generally be upheld if it meets a four-part test from the O'Brien case. 1, the regulation is within the government's constitutional power to enact. 2, it furthers an important or substantial governmental interest. 3, that interest is unrelated to the suppression of free expression, i.e. it's not aimed at the message. And 4, the incidental restriction on First Amendment freedoms is no greater than necessary to further that interest, narrowly tailored.
Okay, so conduct gets protection, but can be regulated if the government has a good, unrelated reason. What about laws regulating speech that are either too broad, capturing protected speech along with unprotected speech, or too vague, making it unclear what's actually prohibited?
Those are two key doctrines limiting speech regulations. A law is void for overbreadth if it prohibits a substantial amount of constitutionally protected speech along with speech that it can legitimately regulate. The concern is that an overbroad law will chill constitutionally protected speech because people will steer clear of the law's potential reach. This doctrine allows a person to challenge the law on its face, even if their own speech could be constitutionally prohibited, which is unusual standing. However, the overbreadth must be substantial, and this doctrine generally does not apply to commercial speech.
Okay. And vagueness.
A statute is void for vagueness under the Due Process Clause if it fails to provide a person of ordinary intelligence with fair notice of what conduct is prohibited. Vague laws are dangerous because they don't guide conduct and allow for arbitrary and discriminatory enforcement by police, prosecutors, and courts. Both overbreadth and vagueness can invalidate a law regulating speech.
And prior restraints. These seem particularly problematic because they stop speech before it even happens, like censorship. How are they treated?
Prior restraints, government actions that prevent speech from occurring in the first place, like requiring a license or permit before speaking or publishing, or getting a court injunction against publication, are the most serious and least tolerable infringement on First Amendment rights. They carry a heavy presumption against constitutional validity. They are allowed only in truly exceptional circumstances needing to survive strict scrutiny. Examples might include protecting national security in wartime, like troop movements, maybe certain pretrial gag orders in criminal cases, or possibly regulating obscene materials, but they are very rarely upheld. The government bears a heavy burden to justify any prior restraint.
Does the First Amendment protect my right not to speak? Or to avoid being forced to express certain views I disagree with? Forcing someone to say something seems just as bad as silencing them.
Yes, absolutely. The First Amendment protects the freedom not to speak just as much as it protects the freedom to speak. The government generally cannot compel individuals to affirm beliefs they do not hold, like saluting the flag Barnett, or to subsidize speech they oppose, though compelled funding of government speech or certain union activities can be complex. However, a state might be able to compel a private entity that opens its property to the public, like a shopping mall, to permit individuals to exercise their own free speech rights on that property under state constitutional law, provided the message isn't likely to be attributed to the property owner. Pruneyard. But compelling private speech is generally disfavored.
What about the government's own speech? When the government speaks, does it have to be viewpoint neutral or can it promote its own message, like don't do drugs?
The government's own speech generally does not need to be viewpoint neutral. When the government itself is the speaker, an example through public service announcements, monuments in parks, state-run programs, it can express a particular message or promote its own policies without violating the free speech clause. However, government speech is subject to the Establishment Clause, meaning the government cannot endorse or establish a religion through its speech.
Okay. And how does this apply to government employees? Can they be fired for what they say?
It's complicated for government employees. The Free Speech Clause does not protect a government employee from employer discipline when the employee is speaking pursuant to their official duties. That speech is considered government speech, controllable by the employer, Garcetti. However, if a public employee is speaking as a private citizen on a matter of public concern, their speech has First Amendment protection. In that case, the employee's First Amendment interest in speaking is balanced against the interest of the state, as an employer, in promoting the efficiency of the public services it performs through its employees. This is known as the Pickering balance. Speech on purely private matters generally has less protection. Also, generally, lower-level public employees cannot be hired or fired based solely on their political party affiliation, patronage, unless political affiliation is a legitimate requirement for the job, like for high-level policymakers or confidential advisors.
That's a complex balancing act. Shifting to where speech takes place, the government's ability to regulate the time, place, and manner of speech often varies significantly with the type of forum. Can you break down the different types of forums and the level of scrutiny applied in each?
Yes, the forum analysis is crucial for time, place, and manner restrictions. The Supreme Court has categorized government property into three main types of forums for speech analysis. First are traditional public forums. These are places that, by long tradition, have been devoted to assembly and debate, like public streets, sidewalks, and parks.
The classic spots for protest.
Exactly. In traditional public forums, content-based restrictions on speech, regulating speech based on its message or subject matter, are subject to strict scrutiny, presumed invalid unless they are narrowly tailored to serve a compelling government interest. Content-neutral restrictions on the time, place, and manner of speech, like limits on noise levels, requiring permits for parades, or restricting protests near certain locations, are subject to intermediate scrutiny. They were permissible only if they are narrowly tailored to serve a significant government interest, like traffic control or public safety, and leave open, ample alternative channels of communication for the speaker's message.
Okay, strict for content-based, intermediate for content-neutral, and traditional forums. What are the other types?
The second type are designated public forums, or limited public forums. These are places that the government has intentionally opened up for public expression, even though they weren't traditionally used for that purpose. Think of a university meeting room made available to student groups, or a municipal theater open for public use. Once the government designates a space as a public forum, even for limited topics or groups, it is generally treated like a traditional public forum for those purposes. So the same strict scrutiny for content-based rules and intermediate scrutiny for content-neutral rules apply within the scope of the designation.
Okay, and the third category?
Yeah.
Everything else.
Pretty much. The third category is non-public forums. This includes all other public property that is not a traditional or designated public forum, places like military bases, the inside of courthouses, airport terminals, beyond the sidewalks, government workplaces, or prisons. In these non-public forums, the government has much greater authority to regulate speech. Content-based restrictions are permissible as long as they are reasonable in light of the purpose of the forum and are viewpoint neutral. This viewpoint neutrality is absolutely key. The government can restrict discussion on certain topics altogether in these forums, for example, no political campaigning in a federal office building, but it cannot allow speech on a topic from one perspective while prohibiting it from another. Content-neutral restrictions in non-public forums only need to be reasonable, rationally related to a legitimate government purpose.
Reasonableness and viewpoint neutrality are key for non-public forums. What about governmental regulation of speech on purely private property? Is that generally permissible?
Governmental regulation of speech on a person's private property will rarely be upheld, as property rights and speech rights often align here. While the government has some limited power, for example, general zoning laws might affect signs, outright bans on certain types of speech on private property, like political signs in a person's yard or window, city of Laduvie-Jaleo, are generally impermissible infringements on free speech.
Okay, now let's talk about categories of speech that receive less or no First Amendment protection, allowing for broader government regulation. What falls into unprotected or low-value speech?
Certain categories of speech have historically received less or no First Amendment protection, allowing the government to regulate or prohibit them more easily. First, obscenity and child pornography. Obscene speech is not protected. To determine obscenity, the three-part Miller test is applied. The average person applying contemporary community standards must find that the material, taken as a whole, 1, appeals to the prurient interest, shameful or morbid interest in sex, 2, depicts or describes sexual conduct defined by state law in a patently offensive way, again based on community standards, and 3, lacks serious literary, artistic, political, or scientific value. This SLAPS test uses a national standard determined by the judge, not the jury. Child pornography is categorically unprotected, regardless of whether it meets the Miller test, because of the profound harm it causes to children.
Okay, obscenity and child porn are out. What about speech that incites violence or fighting words? Are those also unprotected?
Yes, speech inciting imminent lawless action is unprotected. Under the Brandenburg test, a state may forbid speech that advocates the use of force or unlawful action only if the speech is 1, directed to inciting or producing imminent lawless action, and 2, is likely to incite or produce such action. It has to be a real and immediate danger, not just abstract advocacy of violence.
Imminent and likely.
Right. For fighting words, these are words that, by their very utterance, inflict injury or tend to incite an immediate breach of the peace. They are personally abusive epithets, face-to-face, likely to provoke a violent reaction from an ordinary addressee. There must be a genuine likelihood of imminent violence. However, laws regulating fighting words are almost always struck down today as vague or overbroad, as courts are very protective of even offensive speech that doesn't meet the imminent incitement test. Annoying or offensive words alone are not fighting words.
Got it. What about defamation when speech harms someone's reputation? How does the First Amendment limit liability for libel or slander?
In the context of defamation, The First Amendment imposes significant constitutional limits on state tort law, especially when public figures or matters of public concern are involved. If the plaintiff is a public official or a public figure, someone famous or who has thrust themselves into a public controversy, they cannot recover damages for a defamatory statement relating to their official conduct or public status unless they prove by clear and convincing evidence that the statement was made with actual malice.
Actual malice meaning.
Actual malice means the defendant made the statement with knowledge that it was false, or with reckless disregard for whether it was false or not. This is a very high bar, established in New York Times v. Sullivan, designed to protect robust debate about public affairs. If the plaintiff is a private figure, but the defamatory statement involves a matter of public concern, the plaintiff generally only needs to prove negligence regarding the falsity of the statement to recover actual damages, although they might need to prove actual malice to get presumed or punitive damages. If the plaintiff is a private figure and the matter is of purely private concern, the First Amendment limitations are much weaker, and state law largely controls.
Okay, that malice standard is key for public figures. And finally, commercial speech, like advertising. Does that get full First Amendment protection? Seems different from political speech.
Commercial speech that proposes a commercial transaction, like advertising, receives First Amendment protection, but it's considered lesser protection than political, artistic, or scientific speech. Restrictions on truthful, non-misleading commercial speech are subject to a form of intermediate scrutiny under the four-part Central Hudson test. 1. The speech must concern lawful activity and not be false or misleading. False, misleading commercial speech gets no protection. 2. The asserted governmental interest in regulating it must be substantial. 3. The regulation must directly advance that asserted governmental interest. And 4. The regulation must be narrowly tailored, meaning there's a reasonable fit between the government's ends and the means chosen. Not necessarily the least restrictive means, but not overly broad. So the government has more leeway to regulate commercial speech than political speech.
Do the media, like newspapers or TV stations, have any special First Amendment rights beyond the general public? Perhaps a privilege to protect their sources?
Generally, no. The Supreme Court has held that the media, press, has no greater First Amendment rights than the general public. For instance, reporters generally have no special constitutional privilege to refuse to testify before a grand jury or in court about confidential sources, Brandsburg v. Hayes. Any such protection typically comes from specific state shield laws enacted by legislatures, not directly from the First Amendment itself. The press gets the same speech and publication rights as everyone else, but not usually special exemptions from general laws.
Okay, and last, but certainly not least, freedom of association. How does the First Amendment protect our right to gather with others and form groups, political or otherwise?
The freedom of association, while not explicitly mentioned in the text, is recognized as a fundamental right implicit in the First Amendment's protections of speech and assembly. It generally protects the right to form or participate in any group, gathering, club, or organization for expressive purposes. Any infringement on this right, especially regarding political association, may be justified only by a compelling state interest narrowly achieved.
How does this apply in the context of public employment? Can someone be fired for belonging to a certain group?
In public employment, an individual generally cannot be denied a job or fired, based simply upon membership in a political organization, even a controversial one. A person may be punished or deprived of public employment based on political association only if that person, 1. is an active member of a subversive organization that engages in illegal activity, 2. has knowledge of the organization's illegal objectives or activities, and 3. has the specific intent to further those illegal objectives. Mere membership is not enough. It requires knowing participation in illegal aims.
It requires knowledge and specific intent. What about for bar membership, which involves professional licensure and character checks? Are there similar protections?
Similar principles apply. Admission to the bar cannot be denied based on political association unless the candidate knowingly belongs to a subversive organization with the specific intent to further its illegal ends. However, the state may deny bar membership to a candidate who refuses to answer relevant questions about political affiliations if that refusal obstructs the legitimate investigation of the candidate's qualifications and fitness to practice law. For example, questions about willingness to uphold the Constitution. Finally, a criminal penalty for mere membership in an association violates the First and 14th Amendments unless the government can prove that. 1. The group is actively engaged in unlawful activity or advocacy that passes the clear and present danger test, AND. the defendant knows of and specifically intends to further the group's illegal activity. This protects individuals from being punished simply for associating with unpopular or even radical groups, unless they personally intend to promote illegal actions.
Spotting constitutional issues. Chapter summary section.
So, wow, we have covered a truly immense amount of ground in constitutional law. I mean, that was a marathon. Now, the big question for you, the listener, as you're staring down a bar exam question, maybe an essay, how do you actually spot the hidden constitutional law issues? It's a lot of information, and the real trick is knowing how to apply it systematically under pressure.
You're absolutely right. The key is developing a structured, systematic approach, almost like a mental checklist, to identify the relevant constitutional issues quickly and accurately. You can't just dive in randomly. First, always ask yourself, can the matter even be addressed by the court? Is it justiciable? This is your absolute first filter. Before you even think about the substance, can this court hear this case? To figure this out, consider, is the action in state or federal court? If it's federal court, you immediately need to run through the Article 3 case or controversy requirements. Standing, injury, causation, redressability. Does this plaintiff have the right stake? Ripeness. Is it too early? Is the harm speculative? Mootness. Is it too late? Is the controversy over? The prohibition on advisory opinions. Is the court being asked for advice? And the political question doctrine. Is this really a question for Congress or the president, not the courts? Is the action in state or federal court? If it's federal court, you immediately need to run through the Article 3 case or controversy requirements. Think about the timing of the suit. Is it brought too soon, making it unripe? Or too late, making it moot? Unless one of those crucial exceptions like capable of repetition yet evading review or voluntary cessation applies. Is the action in state or federal court? If it's federal court, you immediately need to run through the Article 3 case or controversy requirements. Who is the defendant? If it's a state or state official being sued in federal court, you should immediately flag potential 11th Amendment immunity issues and the broader principle of sovereign immunity.
That's a great initial filter. Okay, so let's say you've determined a case is justiciable and fit for federal court review. How do you then figure out what type of constitutional issue is presented? Where do you look for the substantive problem in the fact pattern?
Right, then you move to the substance. Ask yourself, what type of constitutional issue is presented here? What's the government doing and who is it affecting? Is it about the scope of congressional power? If the facts explicitly say that Congress or the federal legislature passed a law or enacted a statute, you must analyze its constitutional basis. Immediately think, Commerce Clause, economic activity, aggregation, substantial effect, taxing and spending power. Is it a tax or a penalty? Are there conditions on spending? Are they coercive? The Civil War amendments, especially Congress's power to enforce the 13th, 14th, 15th Amendments, is it congruent and proportional? The necessary and proper clause, remembering it's not a standalone power but must attach to another enumerated power, the property power, or Congress's power over citizenship aliens. You need to find the hook for federal power. Is it about the scope of congressional power? If the facts explicitly say that Congress or the federal legislature passed a law or enacted a statute, you must analyze its constitutional basis. Immediately think, is it about state interference with federal power or interstate commerce? Look for action verbs or laws passed by a state or local government. Did a state enact legislation or issue a tax that seems to conflict with a federal law or unduly burdens interstate commerce? This screams federal preemption. Is the field occupied? Is there a conflict? And the dormant commerce clause. Is the state discriminating against out-of-staters? Does it unduly burden interstate commerce? Market participant, exception. Did a state create a licensing scheme that treats out-of-staters differently regarding fundamental rights or economic activity? That points directly to the Privileges and Immunities Clause of Article 4. Is it a state taxing or regulating the federal government, or vice versa? That's intergovernmental immunities and the anti-commandeering principle. And finally, is it about individual rights? This is a huge category, often tested. First, always look for state action. Is the government, federal, state, local, the actor? If a private entity is involved, you need to determine if their conduct be attributed to the state using the public function or entanglement tests. Once state action is established, or if the government is the direct actor, consider the following scenarios. And finally, is it about individual rights? This is a huge category, often tested. First, always look for state action. Is the government, federal, state, local, the actor? If a private entity is involved, you need to determine if their conduct can be attributed to the state using the public function or entanglement tests. Once state action is established, or if the government is the direct actor, consider the following scenarios. If there's a deprivation of life, liberty, or property without adequate procedural safeguards, for example, no notice, no hearing, Think procedural due process and apply the Matthews balancing test. If the substance of the law itself seems unreasonable, arbitrary, or infringes on freedoms, ask, does it impact some specific groups differently based on a classification, triggering equal protection with its tiered scrutiny, strict, intermediate, rational basis? Or does it impact all persons generally by infringing a fundamental right, which leads you to substantive due process and identifying whether a fundamental right is burdened, triggering strict scrutiny, or if it's rational basis? If the substance of the law itself seems unreasonable, arbitrary, or infringes on freedoms, ask. If the government is taking private property for public use, the takings clause should immediately come to mind. Was there a taking, physical or regulatory? Was it for public use? Was there just compensation? If the substance of the law itself seems unreasonable, arbitrary, or infringes on freedoms, ask. And any government action impacting religion, establishment or free exercise, speech, content-based or content-neutral regulation, forum analysis, unprotected speech, or association points directly to the First Amendment, requiring analysis under its specific clauses and tests.
That was a truly comprehensive deep dive into constitutional law. I feel like we've equipped you, the listener, with a really solid framework to navigate these complex scenarios and hopefully answer those tough bar exam questions with more confidence. We've covered so much ground, from the foundational powers of each branch right down to the intricate protections of individual liberties.
Remember, the key isn't just knowing what the rules are, but understanding why they exist and how they interact with each other. Constitutional law isn't just about rote memorization. It's about connecting these dots, the powers, the limitations, the rights, to see the bigger picture of our governing principles. Those distinctions, the underlying rationales, the different levels of scrutiny, and applying that systematic approach we just discussed, that's often what the bar exam tests most rigorously.
It really does. And thinking about all this, it raises an important question for the future, doesn't it? As technology, society, and the challenges facing our nation continue to evolve and grow more complex, how will these bedrock constitutional principles we've discussed today continue to be interpreted and applied to new situations? How do we ensure that both governmental power and individual freedom remain in balance in the 21st century and beyond? What fresh perspectives might you, our listeners, bring to these enduring questions as future legal professionals?
It's such a dynamic and living area of law. Your ability to think critically, to analyze rigorously, and to apply these principles with nuance will truly be your greatest asset, not just for the exam, but throughout your entire legal career.
Absolutely. Keep digging, keep questioning, and keep making those crucial connections. We really hope this deep dive has given you a real edge. Until next time on the deep dive, stay curious.